On this morning's docket, case number 106731, State of Kansas v. Rodriguez.
May it please the court, Michael Barty appears for Mr. Rodriguez. Mr. Chief Justice, I would like to reserve 3 minutes for rebuttal, if I may.
3 minutes is granted.
Thank you. This is a post-trial DNA test that Mr. Rodriguez sought, and his motion was granted. DNA testing was done, and it yielded a sperm sample to which a Mr. Vallejos is in the universe of contributors. There was not a specific match, there was not a hit unique to Mr. Vallejos in those astronomical numbers that we get from DNA, but nonetheless, Mr. Vallejos' DNA profile is consistent, which makes him a donor in the spectrum of people. He is a potential donor. He matched on several of the alleles, but not some of the final ones that would have elevated the numbers to make it unique to him. Nonetheless, the defendant didn't have this information at the time of the original trial. Mr. Vallejos was in the residence at the time of this incident. He was one of the witnesses in the trial. He walked the victim in the case into the bedroom and helped her get into bed. Mr. Rodriguez was accused. There was no physical evidence at all linking Mr. Rodriguez to the crime that occurred. The DNA sample in this case was collected from a pillowcase on the bed on which the attack occurred.
And the person who conducted the testing said that it was not linking him to the crime particularly, correct?
Well, yeah, kind of, not necessarily. And that's because the profile of the victim was not present in the non-sperm sample. Mm-hmm. Our position is that this is betting, and the non-sperm sample may have been there for days, months, or years from someone else, and it is certainly credible and believable that some sperm leaked out from the attacker after the attack. The description, I think, that the victim gave was that the attacker was straddling her and forcing her to perform oral sex on him. He ejaculated into her mouth, and he then withdrew. And I think at that point, common knowledge experience tells us that the penis can leak sperm after the act. And it falls on the pillowcase, which is, I mean, in the facts of this case, it's right there. And we then get this sample that's consistent with Mr. Vallejos. This would have been excellent ground for the defense to present at trial. You know, there was the argument that DNA tests weren't done on Vallejos, but none of them showed it was Mr. Rodriguez. But we've now got a suspect named and linked to this offense. Biologically linked to it.
And that, I think, then means that the test results are favorable to Mr. Rodriguez.
I believe they are favorable to me. They're exactly what he was looking for.
And so that got you past the step in the statute that granted you a hearing. The judge found that it was likely that this was favorable. The stumbling block, I think, or the point at which the court didn't accept your argument was that this would have an impact on the verdict.
Yes, and
probabilistic likely.
Well, yeah, and that's one of the first problem I brief is the language, the semantics.
But but even assuming that, I mean, what makes this so compelling that it would have changed the verdict when there was evidence that Mr. Vallejos had slept in the bed before, and that all of the eyewitness, the victim herself and then the others in the house all corroborate that Rodriguez's movements implicate him, not Mr. Vallejo's.
Yeah, and I don't remember specifically Vallejo's having slept in the bed. There was a question, he was in the house.
On page
And-
22 of the Appellee's brief, they quote
Okay.
some language that from Valerie Famo, the first analyst,
Okay,
that talks about her having been told that Mr. Vallejo's may have had sex in the room, in that bed.
okay. She's a chemist.
She's
I
a
don't-
chemist, yeah. And I think there's detective testimony that backs that up.
Okay, and I'm, maybe, well, yeah, and it is possible that he did that. That's what we don't know, is whether he slept there, whether he had sex with someone there, whether there's some other reason unrelated to the crime that his sperm would be on the pillowcase.
And the jury knew that. I mean, they knew that there was DNA from other people.
Right.
So they already had that fact.
They did.
So what about this new DNA evidence would compel a different reason?
Well, they had information that there was some other DNA there. And this is not just some other guy's DNA. This is the DNA of one of the guys incriminating Rodriguez, a guy in the house at the time of the crime, a guy sitting at a card table, a guy who essentially tucked the victim into the bed. So this isn't a case where, well, maybe somebody else did this, and you've got this huge link of inferences you've got to make Mr. Vallejos the attacker. There are not many links between Mr. Vallejos and this incident. He was right there. He was in the house. He was known, and he actually testified in the case against Mr. Rodriguez. So I think that what this would have given the defense is an argument that Vallejos was the attacker in the case. That we've got someone in the house at the time who committed the crime rather than Mr. Rodriguez. The district court's finding was that a different trial or a new trial would be unlikely to yield a different outcome.
And our standard of review on that is abuse of discretion.
Well, it is, but he didn't use the language of the statute, which is that there's no reasonable probability to yield a different outcome.
And what's the difference between reasonable
Well,
probability and likely?
That's the grand question, the semantic question here. I mean, I think a reasonable probability is lower than likely. And it is semantics because his ruling is not clear. It's not expressed in the language of the statute. It's pretty clear he intended to deny the motion. But there's a real question of whether he's applying the proper standard in the language that he used in rendering his decision. But beyond that, we think he erred in making that conclusion. He put too much emphasis on the fact that there's not necessarily a connection to the present crime, and I think he overemphasized the absence of the victim's contribution to this sample.
And why is that wrong when that's what the evidence is? Isn't that what all the expert testified to, that the absence of the victim's DNA from that mixture excludes it from this particular event?
And that's where we differ. I don't think it excludes it. It makes it an
You don't
area
think,
of
but
argument.
the evidence, that's what the evidence pointed to. Why isn't that satisfactory when all the evidence says it's an exclusion?
Well, it excludes the victim from that sample. And I think the court went too far in excluding this incident from the sample.
Was the victim's DNA found anywhere else on the bed?
I'm sorry?
Was the victim's DNA found anywhere else on the bed? Were there any other stains that contained her DNA?
I don't believe so.
Can I
And
ask
I
a
think-
clarifying question? I understand you're saying with respect to the physical evidence that Vallejo's sperm was the DNA confirmed, or at least would tend to show his sperm was found on the pillowcase.
Yes.
In your brief on page 5, in the facts section, you say that Vallejo's was included in the non-sperm fraction of the DNA sample retrieved from the pillowcase. Is it both, or is it one or the other?
It's the sperm, and I think that must be a typo. He was in the universe of donors for the sperm sample, the sperm part of the sample.
So that sentence at the end of the long paragraph on page 5 is just a mistake.
I believe so.
Okay.
To return to the question of the court's view that the DNA had nothing to do with the incident in this case, I think is a step too far. I think had the jury heard that Vallejos's DNA was present, even if the victim's was not present, there is certainly an explanation for how that would occur, especially when you look at the specifics of what the victim testified to in the case, the manner in which this happened. It seems to paint a picture that it clearly could have happened that way.
Does it make any difference to your analysis when we just clarify that this is the sperm sample versus the non-sperm sample? In other words, assuming it is the sperm sample, that increases the validity of your argument?
Yes.
Because there's plenty of evidence, as I understand it in the record, that he was in the house sitting. You yourself have said he escorted the victim into the bedroom, helped her get into bed.
Yes,
So you're keying this on the fact that it is the sperm sample.
yes.
All right.
Thank you. That's all I have, unless there are further questions.
I have just one clarifying question. Do we know whether or not the district court was proceeding under subsection F2 to conduct the hearing, or F3? In other words, do we know whether or not the district court actually made a finding that this was favorable, or was it inconclusive?
I viewed it as implicit that the court found that it was favorable.
So
And I don't think he articulated that.
Okay. Thank you.
Any more questions? Thank you, counsel.
Thank you.
May it please the court, the appellee state of Kansas appears by Stephen Obermeyer. Let me start off with what the lab report, States Exhibit 1, says, and then go into issue 1 if I could. There is a stain from a pillowcase in the room, and on page 205 of States Exhibit 1, as far as the sperm fraction, the examiner's conclusion is, due to the possibility of an allele dropout, no conclusion can be offered as to whether Javier Vallejos is the source of the partial DNA from this sample. So it does not reach a level for statistical comparison, was I think what he's saying there. As far as the non-sperm fraction in this sample, there's a mixture of DNA from 2 individuals with a male contribution. Javier Vallejos is included as a contributor, and then it goes on to say there is a 66.94% probability of selecting an unrelated individual at random from the population who would be included as a contributor to the mixture of DNA from the sample. So I think that means 2 out of every 3 people could be included as a contributor of this sample. It's not very helpful information as far as saying that Javier Vallejos is the real person who committed the rape and the aggravated criminal sodomy.
So are you saying it's not favorable result?
I think the standard for favorable is pretty low. Judge Ruddick said I would have admitted it at trial if we'd had this information. So I think it's favorable. But is that DNA material enough to get a new trial, I think is what the issue is. I don't think there was a discussion as far as favorable or non-favorable, but if you look at subsection F3 of the statute, if it's inconclusive and the defendant makes an assertion of innocence, then you're back to F2 anyway, as far as whether it's favorable. So I think we kind of get to the same ending spot. So as far as issue 1, did the judge know what he was ruling on? Do we need to remand this for further findings? As far as procedural context, it came to Judge Reddick on remand from the Court of Appeals. So there's an opinion setting out what the standard is and what is to be done. There's briefing from both sides. After the DNA testing is completed, the defense filed a motion for new trial. The state filed a response. There is a testimony of Ross Capps. There's argument by the attorneys as to whether a new trial should be granted or not. And the state basically argued that the jury would have to buy that the mixture is related to this sexual assault, despite the testimony of Deputy Capps, the expert, and more importantly, Mr. Yanis and Mr. Vallejos, the two men who were in the kitchen when their victim left the bedroom and had the outcry evidence, that these two were in a conspiracy with the victim to point the finger at the defendant. That is not a reasonable probability. That argument would fly and as a result produce a different verdict. That evidence in the bedroom was attenuated, that we don't know, that the testimony was that when there's oral sodomy, when the victim's mouth is forced shut and forced to swallow, that if there is any DNA from that, you're going to have saliva along with the sperm, and Ross Capps completely expected to see a combination of DNA. So it was important to him that there was not any of the victim's DNA in that mixture between two male contributors. So Judge Reddick, after hearing all this, says, I agree with the state's analysis. Looking back at this, I would have admitted it at trial, but that isn't the test. There seems to be a logical explanation why Mr. Vallejos' DNA would be in the bedroom and in the bed. There's no evidence from all the evidence at trial or this DNA analysis to suggest that whatever DNA was there was any evidence of this particular sexual assault, that there's any connection between that DNA and the assault because there wasn't any DNA found from the victim. So that was his initial ruling. Then the defendant made a comment kind of protesting that ruling, and that's where we get the comment from Judge Reddick that this was unlikely, that we're now in the semantics as far as unlikely. Does that mean the same thing as reasonable probability of different outcome at trial?
He did. Earlier, I couldn't tell if you were quoting Judge Reddick or speaking for yourself. Did he use the term reasonable probability when saying he didn't think that Yanis Vallejos and the victim were in a conspiracy?
I was reading that from the state's kind of closing argument at that motion hearing. It's at volume 17, pages 32 to 33.
So that's the state's argument, not the judge's finding.
Yes, but then right after that, Judge Reddick asks the state, is your position that since there's no mixture with the DNA, that doesn't tell us very much? The prosecutor says right, and then Judge Reddick makes his ruling that I do agree with the state's analysis here. So that's why I think that he knew what the issue was, and a remand would not be required to have the magic words be stated. And there was no objection to the inadequacy of the findings. The hearing concluded with Judge Reddick saying anything further by either party, and there's no clarification as to that. The standard on appeal as far as issue 2 is whether a reasonable person would agree, or whether no reasonable person would agree with Judge Reddick's ruling in denying the motion for a new trial.
Unless we determine that Judge Reddick used the incorrect legal standard. If he used unlikely instead of reasonable probability and we determine that's the wrong standard, that's also an abuse of discretion, is it not?
That would be one of the three options of an abuse of discretion. I'm not sure that was argued in the brief, but because issue one was really whether it should be remanded for further findings or not. And given the context of the arguments and the briefing and the Court of Appeals opinion, I think Judge Reddick was aware of what the issues were. But if he did misapply the standard, then I guess it gets sent back to have him apply the correct standard as far as the remedy, if that were the case. But the state's contention is that a reasonable person would agree with the denial of the motion for new trial, given the fact of the nature of the assault in this case. And I would point out to counter Mr. Barty's argument about the possible dripping, that the assailant had a towel or some sort of cloth that was placed in the victim's mouth and was in there with him. So the DNA evidence that forms the basis for this motion is not very strong. The state's evidence at trial, you had the immediate outcry by the victim, corroboration by two witnesses who were present, and you also had the defense theory, where identity was really not a defense in this case. The victim knew the defendant, had met him at least 4 times. He operated I think a restaurant. She talked to him that night. He was over at the residence. So she would know him and not be confused. Well, gee, that was Javier and not the defendant. And in fact, at the instruction conference at trial, defense counsel objected to an eyewitness identification instruction, saying it suggests the defense may proffer, in fact, an eyewitness identification defense. That is not the case. There will be argument that the entirety of the victim's testimony should be taken with some skepticism. And he followed that, defense counsel followed that up in closing argument, saying, let me be perfectly clear about this. This is not a mistaken identification case. You've got that identification instruction. You can do with it what you will, but my contention is this is not mistaken identification. This woman is not sure what happened to her. And then he goes on and does make an argument that, maybe it was somebody else, but the primary argument was that it's not an identification case.
The defense again was what? That she didn't know what happened?
That she was in a drunken stupor and was not sure what happened to her. Yes. And initially, in her initial statements to the police, she did not disclose an anal sodomy, which was one of the counts. She later disclosed that, and the jury found the defendant not guilty as to that count. As to the rape count, that was a digital penetration, so there's not going to be sperm or DNA in the bed at that point.
Counsel, I'd like to go back to the sperm sample.
Yes.
And you were referring to, I think it was State's Exhibit 1.
Yes.
I'm going to ask you to maybe give me a layman's translation of what some of this means. For example, you had said the sperm sample, the results were inconclusive regarding Mr. Vallejos. Is that right?
No conclusion can be offered as to whether he was the source of the sperm, the partial DNA profile in the sample. Yes.
On a continuum of an analyst saying all the evidence shows that absolutely he is a contributor, call it 100%, okay? Mm-hmm. Versus on the other end of the continuum saying absolutely he is not a contributor. Mm-hmm. Where does the no conclusion can be drawn fall on that continuum? Do you know that?
I'm not certain as far as what percent you need before they could say that he's a match or part of the profile. I know they look at these charts and these lines and matching things up, but it wasn't enough for him to say that to use it for statistical inclusion and say that 1 out of however many people. would have this. It wasn't enough for that. However, he could not. No conclusion can be offered. So I guess he could not exclude Javier Vallejos from that sample, but it wasn't enough to be a match where he could put a statistical inclusion number on it.
Was the analyst's level of confidence higher with regard to the non-sperm portion of the sample?
Well, I would think so, because he said that he was included as a contributor to the sample
Is that the non-sperm sample?
on the non-sperm fraction. Yes, and that's where we get the 66.94% probability of somebody else having the same.
So he was confident enough to draw some conclusion with respect to the non-sperm portion of the sample.
Certain enough that 2/3 of the people would have, of the random population, would also have that.
Whereas with respect to the sperm portion of the sample, he was not confident enough to offer any opinion.
Correct.
Okay.
Correct.
But significantly, he eliminated the victim as the other contributor to that non-sperm sample, correct?
Correct.
So we know that even if it was Mr. Vallejos, his sperm was mixed with some unknown person,
Correct.
which fits with the fact that he had been sleeping in the bed, and as I understand it, he lived there with his wife, or was married, and he was house sitting for his sister.
That's correct. He was
Correct.
married. His wife was also there that night, and he was house sitting for his
And
sister.
we don't have a known sample for the wife, so.
No.
So the jury, again, we're back to, it's unlikely that that sperm sample, even if Mr. Vallejos is tied to this crime,
Right. And I think that's what Judge
for
Ruddick.
that non-sperm.
Sperm sample.
Yes. And there's.
But as I understand it, even though we call it a non-sperm, it has sperm in it. It's just mixed with other it's just a mixture.
Yes, and there's
Oh, so it
testimony
has
at the
seed
motion
then.
hearing, I think about page 25, where the analyst takes a liquid, spins it in a centrifuge. The top part of it is the non-sperm fraction, and the sperm DNA is like a stronger DNA, and that sinks to the bottom of the test tube. And so that's where we get the non-sperm fraction, and then the sperm fraction is what's at the bottom of the test tube, and why you have two different results.
The use of the word fraction means that they come from the same sample, the same stain.
Yes.
Okay.
Yes.
Thanks.
I think that was everything I wanted to. Well, let me just mention real quickly State versus Haddock. The Court of Appeals calls it Haddock 2, I think, and it might be Haddock 3, I'm not sure. But anyway, State versus Haddock came down after the briefs were written and probably after oral arguments, I don't remember. But I think the Court of Appeals had a good discussion of the analysis in State versus Haddock, where you had a victim who had some favorable evidence with a hair on her finger in the garage at the murder scene that did not match the defendant. And the court looked at that, at all the evidence, the totality of the evidence, favorable and unfavorable, and given all the other evidence, the court did not abuse its discretion in denying Haddock's motion for new trial. And so the same case here, by analogy, and looking at all the evidence, a reasonable person would agree with Judge Ruddick denying the motion for new trial.
And
For any questions?
however inconclusive the sperm sample DNA analysis would have been, Judge Ruddick said, had he done this at trial, he probably would have admitted it
Yes.
for the jury to consider its weight.
Yes, and that's why I think it's favorable, because he would have admitted it. It's just not material enough to have changed the outcome or to get result in a different verdict at trial.
Any further presentation?
No, thank you.
More questions?
Just one. Refresh my recollection, in Haddock, was there DNA from defendant? involved?
Part of the,
Actually, there was victims
The-
on the clothing of the defendant.
right, on the
Okay.
cufflink and
the-
shoes.
And the distinction here is that we don't have any DNA evidence from either side that would link defendant to this crime, do we?
No, we do not.
Thank you, counsel.
Thank you.
You reserve 3 minutes for rebuttal.
The state did mention the Haddock case, and I think there's a distinction in this case from Haddock. In Haddock, I believe the third party was kind of a mystery person, not present at the scene, not in the area at the scene of the crime, for the DNA that was consistent with neither the defendant nor the victim in the case. This case is different. Because we have the presence of the donor, someone in the universe of donors for that sample who is present in the apartment
Sounds
at
like
the
it's a
time.
pretty broad universe, though.
Well,
At least
yeah, it is.
to the level of certainty in that report. I have another question for you on what you've termed your semantic argument. Doesn't the word probable convey something more than possible? Possibly something more than 50%?
I think it's more than possible.
Certainly. And wouldn't you say more than 50%?
Well,
Isn't
And then
our
we've got-
standard for preponderance more probable than not probable? Which
it is.
means
And we've
50%
got,
plus some
but,
unknown margin.
but we don't just say probable. We say probable or not probable to put a line there.
Right.
And
And that's my point, that you
well-
must be past 50% to get there. More probable than not
Okay.
probable.
But can you-
I'm trying to discern some sort of actual language support for
Well-
the difference between reasonably probable and likely.
Right.
Because to me, it's pretty clear likely means better than 50%.
it does, but I think it's more than probable. I think if you put them stepping up, I think
But
I
we're
think you got
not, we're
probable
not
and then
looking,
likely.
we're not looking more probably or not guilty. We're looking at the probability that the jury would take this evidence and determine that the state had not met a beyond a reasonable doubt standard. And so it's
Correct.
not really 50% of whether he's guilty, but 50% of whether the jury would have been persuaded to have reasonable doubt.
Correct.
And does the modifier reasonable raise that probability even more than above
Wow.
50? I mean, 51% may not be a reasonable probability that it would affect the verdict. It's just a probability that it would.
Right.
But what is this, does the reasonable elevate it even more?
I don't know that it does. I don't know that it changes the quantity. It describes that it's got to be a reasonable probability, I guess, as opposed to an unreasonable, which then opens up the question of what's an unreasonable probability. Can you have that? I wrote the words down and tried to make a ladder out of them, and I think something can be reasonably probable that's not necessarily likely. But it is. It's semantics. It's words that we use all the time, and here we've simply got a court making a ruling using words that are outside the statute.
Do you have an opinion on why the legislature inserted the word reasonable for probability?
I don't.
Yeah.
I don't. It sounds like, I don't know. I don't know.
All right, very good. Any further questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement.